Well, good afternoon, everyone. My name is David Tingstad. I'm the chair of the business real estate group here at Beresford booth. We have a bit of a maiden voyage here. I am pleased to introduce you to my partner, Dick Beresford. Dick and I have been together for 27 years. And Dick's got a few years on me, having just passed 50 years of practice. An amazing feat, and he still has his wits about him. So, Dick, welcome to our first webinar. And
thank you. I'm looking forward to it.
Yeah, we're excited to talk about something that's near and dear, frankly, to both Dick's heart and mine. Dick's done tons of receivership work over the years. I've done tons of LLC work over the years, so we thought we'd put together a presentation marrying both of those concepts. Title of today's presentation, as you can see from the screen, Judicial Dissolution and Receiverships. Be careful what you ask for, because you just might get it. And Dick and I get asked these questions all the time. Hey, can't we start a lawsuit and try to wrest control of an entity away from an allegedly bad actor? And sure, you can file a lawsuit, and judicial dissolution is possible, but you need to understand how difficult it is, and you also need to understand whether, in fact, it's something that you actually want. So with that, I'll hop into the right screen, the next screen, and next slide if I can. There it is. And so what we will do, Dick and I will basically be engaging in a conversation about the subject. And so thought we'd start with a little bit of a statutory background, because there's not a ton in terms of statutes that you need to look at. RCW 2515-274 is the LLC statutes dissolution statute. They're similar judicial dissolution statutes in both the Corporate Code as well as the Uniform Partnership Act and Limited Partnership Act. There's not much guidance there. In fact, I'll just quote it for you. Any member can file ask the Superior Court to dissolve a limited liability company when it is, quote, no longer reasonably practicable to do business in accordance with the certificate of formation or the LLC agreement. And then there's sort of a catch-all right after that says, or other circumstances make this dissolution equitable. There is no case law in Washington on what circumstances render dissolution, quote, equitable. But that's where the statute ends. And so it's interesting because, okay, let's say, and we'll get into some of the grounds here in a second, but let's say, Dick, that we stand in front of a judge and we file a motion for summary judgment, and we ask the court to dissolve our LLC, and let's say it owns a piece of real estate. That's where the statute ends. There's literally nothing more there. And so we're left with, kind of, well, what do we do now? And almost invariably, what happens is then one of the parties also asks for the appointment of a receiver, or the court does it on its own. So Dick, maybe you could just introduce the concept of a receiver, what the receiver does and maybe doesn't do, and doesn't have to just be in the context of LLCs, but if I go ask for the appointment of a receiver over my LLC, what does that mean, and what can we expect?
Sure. Well, first of all, a receiver is consider a receiver being almost identical to a Chapter 7 trustee in bankruptcy, and you need to kind of understand that to understand the receivership. And if one were to file a bankruptcy proceedings in Chapter 7 of the Bankruptcy Code, at that point, in a Chapter 7 setting, a trustee is appointed and the trustee's job is to take control of all the assets, liquidate the assets, and sell them and distribute them in accordance with the priorities set out in the bankruptcy code, generally to administrative expenses, then to secured creditors, and then to unsecured creditors. That's a broad simplification of it. So what happened when the Receivership Act, the most recent version of it, was amended and established, that it passed, that the idea was to kind of mimic the bankruptcy code and try to maybe make it a little bit more efficient than a bankruptcy setting. And so now, instead of having a bankruptcy trustee taking charge of the assets, now we have a receiver taking charge of the assets. And that receiver is under the guidance and control of the court, but they got a whole lot of latitude and frankly imagination how to deal with some of these assets. I happen to be involved with one right now that's in the aviation industry, and just so happens we have a receiver that really has a lot of background in the aviation industry. We chose that receiver for that particular purpose, and it's worked out wonderfully.
Well, hold on. Let me ask you a question about that. So let's say we go get a receiver appointed, and let's say you and I are warring members of LLC. What if I don't like what the receiver is doing? What if I think the receiver is not doing a good job of marketing the assets or whatever? What do I?
There's nothing you can. I hate to say it, but there's almost nothing you can do. I mean, you're unless the receiver just simply is not following the law, and not not properly marshaling and liquidating the assets, and not treating the parties right. There isn't anything that you can do. In fact, hence the title of this seminar here is "Be careful what you ask for," because what you're doing in the case that I'm referring to, I happen to represent a major secured creditor who's got a lien on all the assets of the company, and so normally that secured creditor would take charge of the assets and liquidate them, but in this case the receiver is doing it, and if we don't like the way the receiver is doing it, there's almost nothing we could do. We've kind of married that receiver, and we got to stay married to that receiver. So you better kind of anticipate and know what you're looking for before you take that option of getting into a receivership and figuring out who that receiver is going to be. Both of those are critical questions to be answered.
Well, that's a perfect introduction then, back to, now that we have at least some background on what a receivership is. The receivership statute that Dick had mentioned is in RCW 760, and so with that I'll talk a little bit about judicial dissolution, and I've already quoted the statute, and so I have here this. When you go ask for judicial dissolution of your LLC, the court has to answer the question whether or not it's no longer reasonably practicable to do business in accordance with the certificate of formation and the LLC agreement, and so the court will look at those documents, and of course sometimes understanding an LLC agreement is difficult because we have oral LLC agreements, which can certainly make even figuring out what the agreement is difficult. But having said that, the court is answering that question, and almost invariably, and the courts go through the analysis, and they say, first of all, that judicial dissolution is subject that will be rarely invoked. It's an extraordinary remedy. And so oftentimes when you have an entity, let's say it's making money, that it actually is solvent, and as long as it's paying its bills, a court will say, I don't care, I'm not going to dissolve this. The members may be being harmed, what no one else is. As long as the creditors are getting paid and the employees are being paid, a court may not care and just leave the members where it finds them. And that's the other thing. I use the term member. It's important to note that only members have the right to petition for judicial dissolution. So Dick just mentioned the receivership where he's representing the major secured creditor. That secured creditor does not have the right under the LLC statute, maybe by contract or in some other place, may have a right to ask for a receiver, or dissolution, I'm sorry. But only members have that right, not secured creditors. And so if you are a creditor, that's something that you need to bargain for in your loan documents. So I've listed a couple of cases there, Barkalow and Deller. I just put a post on the Washington Business Law blog on Doler, which was a Delaware Chancery Court opinion that went through the process of trying to decide whether judicial dissolution was appropriate. And Barkalow is an Iowa Supreme Court case. I believe it came out last year or the year before. I posted about that previously as well. It's kind of interesting because it had to deal with a family that owned a bunch of property next to the football stadium at the University of Iowa, and one of the members who hadn't contributed a dime was petitioning for judicial dissolution. I would certainly commend both of those matters to you, but both of those cases talk about this no longer reasonably practicable standard. And Beller talked about, hey, if you have somebody who is trying to create a deadlock, which is the classic example of when a court might dissolve an entity. If you are deciding, I'm going to create a deadlock by not agreeing to anything, the court says, no, we're not going to let you get away with that. I'm not going to dissolve your entity just because you're being difficult. But some classic judicial dissolution opportunities are two members, 50-50, they're deadlocked, they can't decide if it's day or night, and creditors are being harmed. If you have that kind of situation, that is a prototypical situation where judicial dissolution may happen. But remember, as Dick said, if you go ask for judicial dissolution and using the classic two-member 50-50 situation, what now? And invariably, when there's judicial dissolution, the receiver is appointed, and that receiver will liquidate the assets, and meaning that the members now have lost total control of their entity. The receiver is not just going to come in and operate it. The receiver is going to liquidate it, and liquidate it at whatever price the receiver decides. None of the members are going to have any right to dictate to the receiver how the assets ought to be sold, in what order, what agents might be engaged to sell those, whether the business will continue to operate during a period, or maybe it's just a piece of real estate. And so now the members are left to the whim of someone who may not even know the members, may not know the company, may not know the assets. And so you've now lost control, but at least you're not dealing with a partner who you can no longer get along with.
Dave, let me add one other practice pointer. For those of you out there, if you are a lawyer or you're a businessman and you've gotten notice that somebody's going to seek the appointment of a receiver, this is a kind of a practice pointer, and that is that it's become the practice in King County and Snohomish and Pierce County that when a receiver is appointed, the party seeking that appointment is going to draft up an order appointing that receiver, but is going to provide in that order that the receiver has got all these various powers and all these certain other requirements under the statutes are waived, et cetera, et cetera. The point is they're creating an animal that is best for them to deal with at the time and may not be the best for you at the involving your particular receivership. So it's important not to just let that application for the appointment of a receiver go by the board. You want to know what sort of order is getting entered and how that compares with what the statute requires. And so, and usually these orders might be 10, 12 pages long. And so it's a complicated analysis. If you're not a lawyer, you ought to get a lawyer involved with at that point before the actual receivership hearing.
Yeah, no, that's exactly right. And so here we are. You've got judicial dissolution under the no longer reasonably practicable standard, but the other standard is this idea of equitable dissolution, and that basically it's a catch-all that allows a court to use its equitable powers to dissolve an entity when other circumstances render dissolution equitable, and you can just kind of let your imagination run wild. And so there's this interesting, dichotomy here, because on the one hand, judicial dissolution is difficult to obtain and it's an extraordinarily rare remedy. On the other hand, you can kind of let your imagination run wild to determine if it's equitable to dissolve an entity. And so as you think about that and how I'm not aware of a single case in Washington that has where an LLC has been dissolved on equitable grounds. It may exist. I'm just not aware of it. So Dick, maybe what we might do now, we've talked about obtaining judicial dissolution. Once a court enters an order of judicial dissolution, and I've got up on the screen the citation to the part of the receivership statute. And by the way, this part of the receivership statute is the grounds for the appointment of a receiver, and it goes on and on and on. And Dick, I don't mean to get in the way of your talk here about receivers, but all of the various grounds for the appointment of a receiver, and 760.025 little I b little 2I all the way down to part T is where it says, okay, and if your LLC is judicially dissolved, that can be grounds for the appointment of a receiver. But again, all it says is that's the grounds for the appointment of a receiver. It doesn't have to appoint a receiver. But what happens, Dick? Once the court enters a decree of judicial dissolution, does the court just pick a name out of a hat? How does it decide who the receiver is going to be? What control do the parties have over who the receiver might be?
That's the difference between a state court receivership and a federal bankruptcy court Chapter 7 proceedings. The state court, I guess, first of all, in answer to your question directly, it depends a great deal upon the judge involved in the case. But usually the judges are going to look at the parties and see what they wish. If I'm representing a secured creditor, a bank, for example, and I found a competent receiver that I think I can work with, and 9 times out of 10, when I go into the court, ask for the appointment of a receiver and suggest that this particular person be appointed, that judge is going to appoint that receiver. That's in the absence of any other contest. That's usually going to be the case. And so that, you think about that, that's a huge amount of power. You get to choose a judge, so to speak, and not that they're necessarily going to rule in your favor. In fact, I've faced several situations where we get a receiver appointed, and that particular receiver decides that whatever they believe is the correct course of action is different than the bank's course of action, and they have the authority to take their own course of action. But usually the judge is going to go along with whatever suggestion you might have in the absence of some other party coming in. And of course, what happens again, 9 times out of 10 is that the bank files or some party files the motion for the appointment of receiver, and almost nobody shows up, and because they don't have a defense to the actual appointment of the receiver because it's so provided in the statute, and so they don't show up, and there's nobody there to suggest any other particular receiver, and so usually that particular receiver that the moving party requests is going to be the party that's going to be appointed, the receiver is going to get appointed.
So is this a situation where you go and you hire your neighbor, make a recommendation to the court, get a resume, or is it more difficult than that in terms of you need to find someone who has qualifications in a certain industry or that sort of thing?
Yes. In fact, that's exactly right. I mean, that's what the judge wants to know. The judge, in signing an order appointing a receiver, they want to know that the receiver they're appointed is competent to handle the chore. And so your job as a lawyer asking for that particular receiver to be appointed is to demonstrate with the CV and a statement of their qualifications to demonstrate that this particular receiver is up to the task. As I said earlier in this talk, the case that I had involved in the aviation industry, I got somebody who was well versed in the aviation industry, and it just and that person is going on and administering that case very well right now.
So when you talk about administration, that receiver is going out and liquidating the assets. Once the receiver sells whatever there is to sell, the airplane or whatever you're talking about in your situation, where does the money go?
Receiver's job is to liquidate all the assets, put them into a bank account, and complete that liquidation process. So now all they've got to deal with is cash, and then they petition for an order authorizing the distribution of those funds in accordance with the normal priorities that are set out in the receivership statute. And I don't, it's a complicated statute, but in very simple terms, the statute provides that administrative expenses, which would be the expense of the receiver, as well, and other administrative expenses might be, for example, expenses that are incurred during the receiver. For example, a case I'm involved right now, the debtor entity has got a lease of some premises, and so the receiver has been in possession of those leased premises for 2 or 3 months, and so they got to pay the rent for that particular period, and that's what's called an administrative priority. So number one, the administrative expenses are paid, and then secured creditors' expenses are paid. And then what I'm saying there is a little bit not exactly true, because there's a little bit of a contest going on between whether or not the secured creditor is going to get benefited, and therefore should the administrative expenses come before secured creditors. But essentially that's in the normal sense, that's what happens. Receiver or administrative expenses get paid first, then secured creditors get paid, and then what's left over, then you have all the unsecured creditors getting paid on a pro rata basis. And in the case that I've got I'm dealing with right now, they expect to have a benefit or a dividend available for the payment of payment to the LLC, and so that's an odd situation. Normally, the entity doesn't survive and doesn't expect to have a distribution. Usually, the whole proceedings are for the benefit of creditors.
So what's maybe let's just take a step back for a second. Maybe talk about what maybe one or two of the benefits of a receivership in an LLC situation, and maybe one or two of the downsides of asking for receivership.
Well, a benefit is you get to choose somebody that's capable of liquidating the assets you're dealing with, and frankly, I don't want to start throwing stones at bankruptcy court receivers or trustees or the U.S. trustee. Some of them are really, really good, and frankly, some of them aren't so good. And so, it's like anything else in life. If you get to choose the girl you're going to take to the dance, go ahead and choose that girl. Don't take it catch as catch can. And so, so you get the big benefit is that you get to kind of be a part of the choosing the person that's going to do the work. And frankly, if you're the person that's choosing that person, even though technically you don't have any further rights, you've got their ear at that point, and so you can work with them in the receivership process. So that's the benefit. Of course, the corollary to that is the detriment is that I saw it in a situation a year or so ago where the receiver was appointed in an agreed deal like this, and the receiver all of a sudden went off and took a right hand turn when the appointing creditor wanted him to take a left hand turn, and they had unfortunately for the creditor, they'd lost complete control. The receiver's got every bit of the authority to act the way they wish. And of course, what we're talking about doing here, when I say actions, the receiver steps in and takes control of. If you've got an operating business or a piece of real estate, you got to deal with employees, you got to terminate their employment, you got to deal with landlords, you got to deal with their existing inventory if it's a business. You got ongoing problems that they got to deal with, and kind of shut off the tap and then get to a point where you can liquidate those assets. So it's a complicated thing for a receiver complicated job for a receiver to accomplish.
So what about expense? Is it an inexpensive thing to go through?
They are very, very expensive. Receivers are not. I got a lot of good friends that are I've got a lot of good friends that are receivers, but so I don't mean to be throwing them under the bus, but they don't come for free, and so it's a big it's an expensive process. And so, again, for example, if you're a secured creditor and you want to go sell a piece of real estate, you might find it a whole lot cheaper to just go judicially foreclose or non-judicially foreclose on that property and go sell it yourself. So you want to pick and choose the right opportunity here. Let's say in that particular setting, in this settings, I guess I've faced recently, one I've got going right now, where you got a piece of real estate that an apartment project is half done. Well, somebody's got to go in and get the necessary financing to finish off that project, and so just foreclosing and not dealing with a property isn't the best option. In that particular case, we get a receiver who's used to dealing with construction projects, and they're going to go out and try to figure out how to get the financing necessary to finish this project off and go finish it off and sell it.
Well, as you can tell, there are a ton of moving parts here, and Dick and I are just about out of time here. But Dick, thanks for hopping on and sharing. You can tell Dick has a wealth of wisdom here, and we enjoy what we do. These are enormously challenging, and so we certainly would welcome the opportunity to help you with through these things. But do be careful if you think that judicial dissolution is your answer. Be careful because you may not like the result that you get. Dick, since it's your first time on the webinar, I'm going to give you the last word.
Thanks very much. I enjoyed it. It's a fun area of the law. One of the areas that lawyers get involved with, where they can exercise some imagination and judgment, getting involved in how you deal with the receivership, and this whole process is an interesting area of the law. So I've enjoyed it, and I commend you to it as well.
Perfect. Thanks, everyone. And so join us next week. I'm not exactly sure what the presentation is about, but I think it's on litigation, and I'm sure it will be riveting. But appreciate it, and give us a call if there's anything we can do to help.
Thank you.